Okay, everybody, we are back now to talk about prosecuting drug offenders. Uh, Very interesting topic, and we've got a few things to cover here, and so I will go ahead and dive right into that. One of the interesting things is the United States versus Armstrong case that I believe your textbook points out, and this really illustrates some of the complexities in prosecuting and sentencing, drug offenders. And essentially, the defendants face substantially different mandatory minimum sentences in state versus federal court. And the argument was that they were targeted for federal prosecution because they were black. Of course, prosecutors denied this allegation and said that that was not true. Um, so then we ended up with a memorandum from the Attorney General at the time, who was Janet Reno, ensuring racial neutrality in the prosecution of drug offenders. And it was issued to all U.S. state attorneys and required self examination of practices and policies of exercising the prosecutorial discretion with regard to these things. In case you all don't know, prosecutors have a great deal of discretion when it comes to choosing whether they want to prosecute a case or not and what charges they wish to pursue. They could pursue a charge that doesn't have a mandatory minimum, or they could pursue one that does have a mandatory minimum. As your criminal justice majors, you've probably heard of kind of the criticisms of mandatory minimums and permanent sentencing and stuff like that, and how it really just kind of takes a lot of the discretion away from the judge and gives it to the prosecutor because the prosecutor gets to decide essentially what the sentence is going to be by how he charges the offense, and the judge doesn't really get a lot of leeway in there. Looking at explaining decisions in prosecutors and judges, one perspective that is particularly useful is the focal concerns perspective. That the prosecuting and sentencing decisions result from the process of gathering and interpreting information related to the offense, the victim, and the offender. And this really looks at the offender's culpability and the desire to kind of protect the community, and really gets into this idea of the dangerousness or trying to figure out the dangerousness of the offender and kind of the blameworthiness of this offender. And so you see some issues with that. In a couple of examples here, that drug offenders, traffickers face harsher treatment than people who've been possessing drugs. Because they're responsible for distributing these dangerous drugs to many potential victims, while the personal use offenders, don't typically cause any harm to others. Your first-time drug offenders are often provided the opportunity to participate in diversion, drug court, and stuff like that, whereas your repeat offenders are not. So looking at drug offenders in the state and federal courts, we started to look at the state courts first, and this is the results or information coming from the Bureau of Justice Statistics from 92 through 2006. And it looks like the 75 largest urban counties. So as I recall, this was the National Center for State Courts data on felony defendants in the largest urban areas. So it's a state court processing statistics data, I believe. But anyway, so approximately one third of all felony defendants were adjudicated in state courts were charged with drug offenses. So that's one third of those, defendants, drug offenses. Between 8,000 and 10,000 defendants were charged with drug trafficking. Uh, Between 700 or 7,500 and 13,000 charged with other felony drug offenses, and there was little fluctuation in the numbers of drug traffickers during this period, but offenders charged with other drug offenses steadily decreased during this time. And so that's interesting to think about. And looking at this from the federal perspective, there's some sources of drug offender data, some listed here. A lot of the stuff that I use comes from the source book on federal sentencing and the U.S. Sentencing Commission data. But you look at this, you find that there are significant differences between federal and state courts, which is not probably a big surprise to you all. And there's been very few federal defendants charged with drug use possession because, like I said before, these tend to be, uh, you know, charged at the state level unless it's a really serious offense. Then the feds won't pick it up because they're not going to be dealing with your minor possession offenses. They'll let the states handle that. They've got a lot going on. And so most are charged with drug dealing or trafficking at the federal level, and this usually comes out of some task force investigations. The feds are usually only concerned with dealing and trafficking. They very rarely will prosecute anybody for possession in federal court. Anyway, uh, in looking at these drug offenses charged by the U.S. Attorney's Office, 14 to 33% of federal cases, mostly drug trafficking offenses. So you got a big chunk of federal cases are coming from drugs from 1980 to 2011. And then prosecutors charging and plea bargaining decisions. Some argue that prosecutors are the most powerful actors in our current criminal justice system now because of the immense discretionary power that they have. That it's been taken away essentially from the judges and given to the prosecutors by the legislation. And the prosecutor has more control over life, liberty, and reputation than any other person in America, says Justice Jackson in 1940. And this is before determinate sentencing. And this is because the prosecutor can choose not to prosecute you at all, and they can let you go. Essentially, they have that power uh, to prosecute or not to prosecute. Right? It's the most critical decision. So after filing a formal charge, the prosecutor has the flexibility to reduce to a lesser offense or even dismiss it, right? Or null pros the case, which means that withdrawal prosecution. Looking at, there's been some research into prosecutors' charging decisions. Rod Ingen, and colleagues, I don't remember who the other people were on this paper, but essentially they examined 294 felony drug offenders in Washington, and they studied factors that look at things that affect charging decisions. And they found that the likelihood of defendants being charged with a more serious offense is greater for older and male defendants. That's a big surprise there, right? And found that no charging differences for defendants across race and ethnicity, which that's a good thing to see. That doesn't look like there's any apparent discrimination going on there or disparity across race or ethnicity. In this other paper by Lyons and the rest of these folks, looked at a sample of people in Cook County. For those of you that don't know, Cook County is Chicago. So you've probably heard of the Cook County Jail. There's been a few things on that before. But anyway, they found that defendants' race and ethnicity did affect the likelihood of prosecution in Cook County. And blacks are 2 times more likely than whites to be prosecuted, and Hispanics are kind of right here in the middle at 1.6 times more likely than whites. So it's not quite as much as if you're black if you're Hispanic, but it is more than white. And then looking at the federal level of prosecutions, there's limited research on this, but one study looked at drug offenses, about 40% of the sample, and found that the higher number of charges filed, female defendants, defendants who were non-citizens, and Hispanic defendants were big predictors of their likelihood to charge, and those with the best chances of charge reduction. So that means you were originally charged with a more serious offense, and then they reduced it to a lower offense. Prosecutors will often do this as kind of a part of a plea bargain to say, well, if you plead guilty to this lesser offense, then we'll take that and we'll just plead this out, and we'll give you probation or a smaller sentence. Um, and one possible explanation for this is that they were overcharged initially. And typically, prosecutors will charge people with the most serious thing that they can, knowing that then they can get them. It makes it easier for them to get the defendant to plead guilty to a lesser offense down the road, and then they don't have to go to trial, which saves them a lot of time. Looking at this, there's some other factors that predict plea agreements by Blanco and Spohn. Uh, the district where the case was adjudicated, the role the offender played, criminal record, whether the primary drug type was meth. If it was meth, that apparently makes a big deal. Females are more likely than males to have the most serious uh, charge dismissed. And again, we see that race and ethnicity has no effect on the plea bargaining decisions, which is good to see. So filing charges that trigger mandatory minimum sentences. This is an interesting topic as we talked about mandatory minimums. And when you think about mandatory minimums, you usually see your violent crimes, your firearms, drug crimes. This applies to drunk driving nowadays. When you're convicted of drunk driving on multiple offenses, you usually have a mandatory minimum sentence that the judge has to give you, and they cannot suspend it. And obviously, the goals of this are kind of deterrence and incapacitation, so to speak. Um, and as I've kind of alluded to, one of the big criticisms of this is that mandatory minimum sentences kind of give all the power to the prosecutor. They put the prosecutor in the position of the judge that they get to decide what you're charged with, and then if you're convicted, which most people usually are, then it triggers that minimum sentence, and the judge cannot depart from it. There is one interesting thing when it comes to I'm sorry, not judge, drugs and sentencing departures. There's something known as a 5K1 sentencing departure in the federal government, and this is what is known as a substantial assistance departure. For those of you that do not know, a substantial assistance departure is what happens when you snitch on someone. So this happens very often at the federal level because the DEA and other agencies are usually trying to climb this ladder and get to the person that is at the top. They want to arrest the highest ranking person they can, and so they will arrest someone and then they will try to get them um, to turn over and essentially snitch on the people that sold the drugs to them or the people that they're working for and stuff. Um, and if that happens, what can happen is the U.S. attorney can motion for the downward departure for a lesser sentence, or they can amend your charges to a lesser offense, or even just null process them completely and put you in the witness protection program and all that good kind of stuff. Of course, you must help with the investigation and the conviction. Oftentimes, would be required to testify against the other people too. And this happens very often when people are faced with spending 30 or 40 years in prison. They're like, well, if I can go home in 5 years, if I just have to tell you about what this other person did, then they very often do so. And that's why this is such a common practice because U.S. attorneys and federal law enforcement agencies know that it works. Um, so, a couple of cases dealing with this. One is Melendez versus U.S. in '96. It says that this 5K1 departure does not allow a reduction beyond the mandatory minimum unless it's specifically written into that. And that is often not the case. And this is a side note. Now, after the U.S. v. Booker decision was passed, they've kind of told the federal judges that these are not really binding guidelines. The sentencing guidelines are not binding. The mandatory minimums are. They cannot go below the mandatory minimum. But when it comes to the guidelines, that at the federal level, judges can uh, uh, divert and give you a harsher sentence or a lesser sentence from what the guidelines recommend after the Booker decision. However, the judges have to write in their rationale as to why they're giving someone a different sentence with regard to the sentencing guidelines. And that very rarely ever happens because the judges don't like to do the paperwork and write that stuff in there. So they just go with what's in the guidelines. Anyway, so Nagel and I don't even know how to pronounce this person's name. They focused on guideline circumvention in 3 U.S. district courts. For those of you that don't know what guidelines are, it's essentially this worksheet, and I've got it on D2L. I encourage you to look at it. And I usually give students an assignment to to look at the guidelines and figure out what the sentence is for a hypothetical offender. And essentially, you get certain a number of points for your criminal history, the seriousness of the offense, whether you had a weapon, and various other things. And then these points they then are added up, and then you will be kind of given a sentencing range, maybe like 3 to 5 months, or 100 months to 120 months, or something like that. And so that's the range that the judge is supposed to sentence you within. So if your range is between 100 months and 120 months, then the judge can give you anywhere from 100 to 120 months as your sentence for that. And that's based upon the sentencing guidelines, like I said. And so, looking at Nagel's study, they found that the definition of substantial assistance varied among jurisdictions, and that race and ethnicity play a factor for male offenders. So, what do they consider to be substantial assistance? Maybe in one jurisdiction, maybe you have to testify against multiple people, or maybe in another jurisdiction, you just have to give them the phone number or tell them where the person lives that is the big drug kingpin or something. So that what they really want as substantial assistance essentially varies, and apparently the race and ethnicity plays a role there, and I would suspect that they probably give to people of racial and ethnic minorities to give them more assistance, right? And require more of them if that's such an issue. So anyway, that's kind of the nuts and bolts and the high points of sentencing drug offenders in the United States these days. So with that, I will kind of sign off, and I will see you all next time. Have a good one.